They fined Elon Musk $3.2 million and expected him to just pay it, but what they didn't expect was for him to walk into the courtroom alone, no lawyers, no excuses, just holding one sheet of paper, and completely take apart the entire ruling right in front of the judge. The judge asked, "Do you understand the terms of the penalty, Mr. Musk?" And Elon replied, "I do. Now I'd like to respond." That's when everything changed. He calmly reached into his jacket, pulled out the paper, unfolded it once, and laid it flat on the desk. "I'm not disputing what I said," he began, "I'm disputing whether the gag order covered it." The room went silent. He looked directly at the judge and said, "The order in question, Section 35B, includes an exception, subsection 3, public safety disclosures, nonspecific, good faith." The judge blinked, reporters looked at each other, and no one moved. Elon didn't even flinch and continued, explaining that the statement he made didn't name anyone or reveal sealed documents. It simply warned about a manufacturing issue that posed a possible safety risk to consumers, and that's not defiance, that's responsibility. Now the judge was really listening. "You're referencing a federal exception?" the judge asked. "Yes," Elon replied, "and the precedent, Stanfield versus U.S. Tech Holdings, 2004, Ninth Circuit. It ruled that disclosures made to prevent harm, even during sealed proceedings, are protected if made in good faith and without revealing classified material." He wasn't trying to show off or be charming, he was precise. The judge stared at him and asked, "Do you have legal counsel?" And he calmly replied, "No, because I don't need a lawyer to read your own order." That's when everything shifted. The $3.2 million fine was still in play, but now the actual law was too, and for the first time in the entire case, the judge didn't know what would come next. She didn't respond immediately. Instead, she leaned back slowly, eyes fixed on Elon, fingertips pressed together like she was thinking through a problem that shouldn't even exist. "This isn't a theoretical debate," she finally said, "this is a federal penalty." Elon didn't blink and responded, "It's not theoretical. If the fine ignores the actual wording of the order, then the penalty doesn't just overreach, it falls apart." No one expected that kind of answer, not from him, not from anyone standing alone in a federal courtroom. "You're challenging the court's interpretation of its own ruling?" she asked. "I'm correcting it," he replied. Subsection 35B. 3 was ignored, and if courts can fine someone for something the order doesn't clearly forbid, then there's no limit to that power. That's not enforcement, that's control. A young prosecutor nearby shifted uncomfortably. A paralegal leaned in and quickly whispered something to her boss, and even the judge's clerk stopped what he was doing. "Mr. Musk," the judge said, her tone more serious now, "do you understand what you're suggesting, that the court may have gone beyond its authority?" "Yes," he said respectfully, "that's exactly what I'm suggesting," and it didn't sound arrogant, it felt like something he'd been patiently waiting to say for weeks, calm, practiced, but completely genuine. "Do you have any supporting documentation?" she asked. Musk nodded and didn't hand over a legal brief or a thick binder. Instead, he reached into his jacket and pulled out one more folded sheet of paper. "This is the final transcript of the March 11th protective order, pages 3 and 4. The clause is in the third paragraph. I highlighted it." The judge took the paper, scanned it, then paused. Something clearly hit her. She looked up, slower this time, and asked, "Why didn't you just let your lawyers file a motion?" "Because this wasn't about strategy," Musk replied, "it was about accuracy." There was a beat of silence, and then the judge turned to her clerk and said, "Get me the full record from March 11th and a copy of Stanfield versus U.S. Tech Holdings." The atmosphere in the room changed instantly. This wasn't just a hearing anymore, it had become a standoff, and the judge, known as one of the toughest in the district, had just taken her first step back. By the time court resumed after the recess, the courtroom had completely transformed. The gallery was packed, not a single empty seat, and reporters had returned not just from local media but from national outlets, some even standing shoulder to shoulder in the back holding voice recorders like weapons. Even rival attorneys had slipped in just to watch, because now, everyone wanted to see if Elon Musk could actually pull it off. When Elon Musk walked back into the courtroom, nothing about his appearance had changed, same suit, same calm expression, but the energy in the room was different. This time, everyone was focused on him. Judge Colton returned holding a legal pad filled with underlines, arrows, and sticky notes, and she didn't sit right away. "I've reviewed your materials," she said, "and I've also reviewed the full transcript from the March 11th hearing." Then she took her seat, and the room fell completely silent. She lifted the paper Elon had given her earlier and said, "You were correct. The exception clause in subsection 35b(3) does allow for public safety disclosures under specific conditions." She paused, holding the silence for a second or two before continuing. "However, those conditions are very narrow. They only apply if the statement is made in good faith, is nonspecific, and is clearly intended to protect consumers from imminent harm." Looking directly at Elon, she asked, "Your comments were made during a press event 2 hours after the hearing. Are you saying you hadn't received the full gag order at the time?" Musk nodded once and replied, "I'm not claiming ignorance. I received the oral summary during the hearing, but the full written version wasn't emailed to me until 6 hours later. By then, the press had already published my remarks." He paused briefly and added, "So yes, the timing is my responsibility, but the intent was protective, not defiant." The judge tapped her pen, thinking. Once, then again, the judge tapped her pen and asked, "And you stand by the statement itself?" "I do," Musk replied. "Even if it means violating a courtroom restriction?" she pressed. "I believe the statement fell within the exception," he answered. She leaned forward and said, "Then say it plainly, what was the risk?" Without hesitation, Musk replied, "Our internal audits found a flaw in a battery component used in pre-release models. It wasn't confirmed, but serious enough that we paused production. If the market misunderstood it, it could have caused panic, but if we ignored it and the flaw turned out to be real, people could have gotten hurt. That was it, clear, sharp, no theatrics, just purpose." A quiet murmur moved through the gallery. The judge narrowed her eyes and said, "So you're asking the court to see your statement not as contempt, but as a preemptive act of public safety?" "I'm not asking for leniency," Musk replied, "I'm asking for alignment with your own ruling. That's all." At the government's table, the prosecutor scribbled furiously onto a legal pad, and a younger lawyer leaned over and whispered, "He's turning it into precedent." The lead attorney didn't respond. She knew he already had. The judge looked down at her notes, then back up and asked, "You've also cited Stanfield v. U.S. Tech Holdings. What do you believe that case protects you from specifically?" Musk folded his hands and calmly said, "In Stanfield, the Ninth Circuit ruled that disclosures made by executives, when aimed at public interest and not revealing proprietary or classified information, are protected, even under a gag order, so long as the gag's language doesn't explicitly ban that kind of speech." He leaned in slightly, not aggressively, just with quiet intent. "And in this case, Your Honor, the language didn't." She stared at him for several seconds, then slowly leaned back in her chair, and for the first time all day, said nothing. The silence stretched long, every eye in the room locked on her. Finally, the judge turned to her clerk and said, "Bring me the original docket from the March hearing, and I want the internal memo from the special counsel's office that outlined the scope of the gag order. I want to compare the language." The clerk nodded and rushed out, and the judge looked back at Elon. "You understand the consequences of what you're doing?" she asked. "Yes," he replied. "You're not just challenging a fine, you're challenging the discretion of this bench." "I'm challenging how it was applied," Musk said calmly. "And if I reject your argument?" she asked. "I'll accept it," he answered, "but I won't regret making it." The back row of the courtroom stirred again, and a former federal clerk in the gallery whispered, "He's not bluffing," to which someone quietly replied, "No, he's building something." The judge tapped her pen one final time and said, "We'll reconvene tomorrow morning at 10 a.m. I'll deliver my ruling then. Court adjourned. No one moved as Elon Musk walked out, and one camera captured a photo of the judge's desk. In front of her sat a single handwritten note from during the hearing that read, "He didn't come to argue, he came to correct." The next morning, the courtroom filled up before the doors even opened. Attorneys stood shoulder to shoulder, reporters lined the back wall, and even law students skipped class just to get a seat. No one came just to witness a fine, they came to witness the answer to a bigger question. Can someone out-argue a federal penalty using nothing but the law? Elon Musk walked in just like he had the day before, same suit, same calm expression, same silence, but the courtroom didn't see him the same way anymore. He wasn't just a defendant now, he was a challenge. At exactly 10 a.m., Judge Colton entered, holding a thick folder in one hand and a legal pad in the other. She sat down slowly and looked directly at him. "I've reviewed the March 11th hearing transcripts, your cited case law, and I've conferred with my legal panel inside the district," she said, and that last sentence hit hard. Judges don't do that unless the ruling has implications beyond just the case. This court finds that Mr. Musk's statements did, in fact, violate the spirit of courtroom confidentiality, she said, then paused. The word, however, dropped into the air like a match. The original $3.2 million penalty exceeded the limits granted by Section 35B of the protective order. A ripple of reaction moved through the room, but Elon didn't flinch, not a blink. The clause you referenced, the exception in subsection 3, was not fully considered during the original contempt filing, and your citation of Stanfield v. U.S. Tech Holdings is both accurate and relevant. She looked down once, then back up and concluded, the court is reducing the penalty from $3.2 million to a symbolic $25,000, acknowledging the procedural violation. While respecting the legal foundation of your defense, she closed the folder and said, "This is not a pass, Mr. Musk. This is a correction. You did not override this court, you reminded it of its limits." There was no applause, no outbursts, just stillness. Everyone in that room had just witnessed something extremely rare, a courtroom reversing itself, not under pressure, not under protest, but under reason. Musk stood and said, "Thank you, Your Honor." But she wasn't finished. "One more thing," Judge Colton said. "This outcome was not influenced by your wealth, status, or name. It was influenced by the clarity of your argument. This courtroom responds to law, not personality." He nodded, and that was it. Court adjourned. Even as the judge stood and turned away, her final glance lingered, not in frustration, not in triumph, but in thought, as if she knew this wasn't just a ruling, it was a moment. And Elon Musk had written it with one sentence and 2 pages of law. The ruling hit the media before Musk even left the building. Judge slashes $3.2 million fine against Musk after he cites federal law, and Musk wins courtroom face-off with no lawyers. By the time he stepped into the hallway, the cameras were already waiting. He didn't stop, didn't wave, just walked straight through, calm, focused, untouched. Because for Elon, it was never about the headlines. It was all about the principle, and soon, clips from the hearing started spreading online. No theatrics, no shouting, just one man calmly quoting subsection 35B. 3. Dismantling a courtroom penalty line by line. Commentators were at a loss for words, calling it brilliant, dangerous, and unprecedented, but they couldn't ignore it. Law students studied it, professors debated it, and judges across the country quietly revisited their own rulings, asking themselves, what if he's not the exception, but the beginning? In her chambers, Judge Colton sat alone, reviewing her notes. Her phone buzzed constantly, but she wasn't focused on the press. She was thinking about one line Elon Musk had said the day before, "I don't need a lawyer to read your own order." It wasn't disrespect, it was accountability. In a system built on power and precision, he had used both. Later that week, a university lecture titled "The Fresno Defense" posed a question to its students. What happens when the courtroom is forced to listen, not to authority, but to accuracy? Across the country, the system was listening. Elon Musk had proven something most had stopped believing: you don't have to break the rules to beat them, you just have to understand them better than anyone else.